And so, those are some of the examples of the more skeptical aspects. There's also, of course, talk about the distinction between DOJ's position and the NRA's position on this, which
Yes.
DOJ was mostly focused on the alleged meeting where Vula was said to have pressured, I think you said it was Lloyd's of London in that case, into dropping the NRA in exchange for more lenient treatment on other potential infractions that the company had racked up. The DOJ or the government's position was that that's clearly crossing the line, but maybe the other actions aren't, especially the guidance letter.
Right.
Or at least they had this thing about like 4 paragraphs of the guidance letter were okay speech, and then maybe the last paragraph slips into...
It was kind of the other way around. It was like 4 paragraphs stating a manifesto on guns and gun advocacy and why it needs to be restricted, and then a paragraph of how this could be reputational risk. And so, again, it was essentially restating the state's political position and then using this hook to connection to the area of regulation and saying, we're going to use this to persuade you not to do business.
Do you think there's any practical, like with how the court might rule on this, do you think there's much of a practical difference between the government's position and your position or the NRA's position?
Not in the overall outcome, in that if the Solicitor General's position prevails, it will essentially still send the case back for trial on the merits. What they're trying to do is carve out sort of a narrower way to get there. Can they uphold this First Amendment rule, the Bantam Books rule, but do so by focusing on a narrower range of government action? And this is action where you actually have a regulatory action taking place. Our position is the broader one, and the position that similar to what the NRA was arguing, and that is it isn't just limited to actual regulatory actions where you're writing these things into consent decrees. It can also include threats of action, even where the government may not have full authority to do a particular thing. They can certainly make your life difficult in a number of ways. And so threats of government action, and not just government action itself, should still qualify for this kind of informal violation of the First Amendment, or violation of the First Amendment by informal means. And so that's why I think the broader approach makes more sense. And we'll see if the court wants to carve a narrower path or whether it wants to have a broader path. And as I say, this is interrelated with the arguments that were presented to the court in Murphy versus Missouri, because that was all about trying to locate the line where the government has gone too far, or what actions by the government would be permissible.
Right. And the other interesting thing on that point, to me, when listening to oral arguments, were that I guess all the parties seem to agree, including Vula's lawyer, that the standard should be they all wanted the same standard. There's this Second Circuit test that has 4 parts, and I guess the disagreement is just over whether Vula whether she actually meets any of these standards, and then the further disagreement between the government and the NRA is which of her actions meet the standard.
And then that's actually fairly rare for a Supreme Court argument like that, where people agree on the basic controlling principle, and then the question is whether it was applied correctly. What was interesting here was that the Second Circuit, in rejecting the NRA's claim, did articulate, as you say, a 4-part test that looks at the words that were used and the tone in which they were delivered, whether it was reasonably perceived as a threat, whether or not there was some regulatory authority backing the government's claims, and then whether or not it was threatening some sort of adverse result. And so those were the elements, non-exclusive elements, but the ones that you should look for. And it's interesting that everyone agreed that those were or at least relevant factors that should be considered. And then the question is really how to apply them to the facts that were alleged in this complaint. What was interesting is at one point, Justice Kavanaugh just asked David Cole of the ACLU, are you good with those four elements, and that being the test? And before David Cole could even say yes, Kavanaugh said, "Well, that's enough for me." That's all I
Right.
need to know. And so,
Yeah, he said it's fine.
yeah.
And there was a pretty good joke in there too. I think Neil Cattell, who's representing Vullo, said that I think he was asked by one of the justices whether, in a brief, he said this was an easy case to decide in favor of Vullo, and he was asked if he stood by that, and he said yes. And then when they got to the rebuttal from Cole, the ACLU lawyer representing the NRA, he said the same thing.
He said, "There's one point on which we can agree. This is an easy case,"
which got a laugh from the justices. So, I guess after a full day of oral arguments on the same basic topic,
at that point in the day, you can use a good laugh.
Yeah. So, it'd be really interesting to see where they come down. But that was, I think, a pretty fascinating aspect of this particular case, is that everybody seemed to agree on the standard. It's just whether or not it was applied right by the second, because the Second Circuit basically said, some of these factors were hit, but she was using persuasive language instead of threatening language. And so that,
right. Well, persuasive language, if what you're saying is something in the order of, you got a nice business here, it'd be a shame if something were to happen to it. And
that's where the disagreement comes.
Yeah,
is that
that's essentially the message in these sort of jawboning cases, where you have governments trying to tiptoe up to the line and hint very broadly that bad things will happen if you don't go along. And that's what I think what's so dangerous about these cases, because where you do have clear First Amendment standards, as you do in a matter like this, you can't pass a regulation or adopt a law that says that an advocacy organization can't take positions we don't like as a state. If you're permitted to hint broadly and rattle the saber of using state regulation to achieve the same result, then you've just undermined the rule of law.